Signing the M&A deal is just the beginning. True success depends on what happens after closing, when two organizations must become one. In Vietnam, post-merger integration is not only an operational challenge, but also a legal one. From restructuring staff to updating licenses, from contract migration to regulatory filings, each step carries legal consequences. In this video, we explore how to manage post-merger integration legally and effectively in Vietnam. Many businesses focus on financial or cultural integration after M&A, but neglect legal integration. This can lead to operational delays, compliance breaches, and loss of shareholder value. In Vietnam, where regulatory filings are strict and timelines matter, legal integration must be tightly managed. Done right, it protects your investment and accelerates business consolidation. Post-closing, one of the first legal steps is determining the new corporate structure. Will the acquired company be merged into the buyer's entity, or continue operating as a separate subsidiary? Each option has licensing, tax, and operational implications. Legal teams must evaluate the most efficient structure and update the enterprise registration accordingly with the Department of Finance. If the ownership or governance model has changed, the company's charter must be amended to reflect new voting rights, board composition, and shareholder roles. This requires official filings, board resolutions, and sometimes notarization. Internal policies such as signing authority, power of attorney, and internal controls must also be revised to align with new management. Post-merger often involves workforce consolidation. This may include terminating redundant positions, transferring employees between entities, or adjusting employment terms. Under Vietnamese law, these actions require careful planning, advance notice, and in some cases, employee consent. Social insurance must be updated, and labor contracts aligned with new employer details. Mishandling this step can lead to lawsuits or inspection penalties. Customer and supplier contracts signed with the original company may need to be assigned or novated to the new entity. Vietnamese law requires written consent from counterparties for assignment of contractual obligations. This process can be time-consuming and must be prioritized. Key terms like pricing, credit terms, and dispute mechanisms may also need renegotiation under the new structure. If the merged entity operates in a licensed sector, post-merger updates must be filed with the relevant ministries. This may include updated operation certificates, management changes, or expansion of scope. Licensing under the old structure may no longer be valid. For example, education, logistics, and healthcare businesses must notify or reapply depending on the extent of change. Post-merger, companies must consolidate accounting systems, unify tax codes, and prepare combined financial statements. This may involve amending tax registrations, notifying authorities, and aligning ERP systems. Transfer pricing policies must be reviewed if the merged business involves intercompany transactions. A tax compliance audit is advisable to identify and resolve gaps early. If physical assets such as factories, offices, or vehicles are transferred between entities, titles and leases must be updated. In Vietnam, land use rights and long-term leases must be re-registered with land authorities. Failure to update may result in disputes or affect your ability to mortgage or sell the asset in future. Asset transfer agreements and valuations must be well documented. Stakeholders such as banks, insurance providers, and government agencies must be notified of the new entity structure. Failing to inform a commercial bank, for instance, may freeze access to accounts. Regulatory bodies may require updated disclosures. Public communication must also be aligned with legal changes, especially in deals involving brand mergers or changes in legal representatives. Conducting a post-merger legal audit helps confirm whether all required filings, updates, and registrations have been completed. It also allows the identification of residual risks or incomplete actions. This audit should be completed within 3 to 6 months after closing and documented thoroughly. It can serve as legal evidence of compliance and reduce future disputes. At LTS Law, we provide hands-on legal support during the post-merger phase. We handle corporate restructuring, license updates, employee compliance, contract transition, and regulatory filings. Our legal team coordinates with your HR, tax, and finance departments to ensure full alignment. We simplify complex integrations so that your business can move forward with legal certainty. A successful deal does not end at closing, it is only complete when integration is done right. Let LTS Law support your post-merger legal integration in Vietnam. Visit lts.com.vn to schedule a consultation. Legal clarity now means stronger performance tomorrow.